In this video, I'll explain the 5 mistakes to avoid in Florida residential construction contracts. And by the end of this video, you'll learn how to protect your money, your property, and your legal rights before a single nail gets hammered. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I've spent years helping clients understand complex contracts, and I can tell you that construction disputes are some of the most painful legal battles a homeowner can face. Every year, homeowners in Florida lose thousands of dollars because of one document they didn't read carefully enough: the construction contract. It happens more often than you think. A homeowner hires a contractor, the project goes sideways. Then they look at the contract and realize they have almost no protection. So let's get into the 5 mistakes to avoid in residential construction contracts in Florida. And stay until the end, because mistake number 5 is the one I see destroy the most deals. All right, mistake number 1 is failing to verify the contractor's license and insurance before signing anything. This sounds basic and it sounds like common sense, but you would be stunned by how many homeowners skip this step. They meet a contractor at a home show. They get a referral from a neighbor. The price sounds right, so they shake hands and they sign a contract. But here's the problem. In Florida, contractors are required to be licensed by the state through the Department of Business and Professional Regulation. This is not optional. It's the law. If your contractor is not properly licensed, your contract may be unenforceable. Let me say that again. The contract itself can be deemed void. Now think about that for a moment. You have paid a deposit, work is started, then something goes wrong. You try to enforce the contract in court. The judge looks at it and says, this contractor was never licensed. You may also have just lost your legal standing to recover damages. And insurance matters just as much. If a worker gets injured on the property and the contractor has no workers' compensation coverage, guess who might be liable? That's right, you, the homeowner. So before you sign anything, go to the DBPR website and verify the license, ask for a certificate of insurance, and do not take their word for it. Verify it yourself. Mistake number 2 is agreeing to vague or incomplete scope of work. This is where things start to unravel on almost every bad construction project that I've seen. The contract says something like, remodel kitchen per discussion. Well, that is not scope of work. That is a recipe for a lawsuit. A proper scope of work should read almost like a blueprint in words. It should describe every task. It should name specific materials. It should include brand names, model numbers, colors, and grades where applicable. It should outline what is included and what is not included. Here's a real scenario I dealt with. A homeowner contracted for a bathroom renovation. The contract said, install new tile flooring. The contractor installed the cheapest ceramic tile available. The homeowner expected porcelain. There was nothing in the contract that specified the type of tile. The contractor technically fulfilled the agreement. That dispute cost a homeowner thousands of dollars and months of frustration, all because of 3 missing words in the scope of work. Now, if your contractor pushes back on adding detail to the scope, that is a major red flag. A good contractor welcomes clarity. It protects both sides. Mistake number 3 is agreeing to an improper payment schedule. Let me be direct. Never pay a contractor the full amount up front. I don't care how good the reviews are. I don't care how your best friend vouches for them. Paying everything before the work is done removes your leverage entirely. In Florida, there are specific statutes that govern how payment should be structured in residential construction. Florida Statutes 489.126 makes it unlawful for a contractor to accept more than 10% of the contract price as an initial payment unless the contractor has certain financial safeguards in place. The smartest structures tie payments to milestones. You pay a reasonable deposit, then you pay after the foundation is complete, then after framing, then after the major systems are installed, then a final payment upon completion and inspection. Each milestone should be clearly defined in the contract, and each payment should correspond to verified completed work. This is how you maintain control of the project. I have seen homeowners pay 70% of a contract price with nothing but a demolished kitchen to show for it. The contractor disappeared, no license bond, no recourse. Do not let that be you. Now, before we get to mistake number 4, I want to ask you something. If you are finding this helpful so far, take a second to hit that like button. It helps more homeowners find this video. And if you want more practical legal tips like this, subscribe to the channel. I put out content regularly to help you protect yourself and your business. All right, let's keep going. Mistake number 4 is ignoring the dispute resolution clause. Now, most people do not read this section. It is usually buried towards the end of the contract. It looks like standard legal boilerplate. But this clause determines what happens when things go wrong. And in construction, things go wrong more often than they go right. Some contracts include mandatory arbitration. That means you waive your right to go to court. It means you must resolve the dispute through a private arbitrator that may or may not be in your favor depending on the situation. Other contracts include mediation requirements. Some include forum selection clauses that force you to litigate in a specific county. Some include attorney fees provisions. Some don't. Here's why this matters. If you end up in a dispute over $200,000 renovation and the contract says you must arbitrate in a county 3 hours away with no right to recover attorney's fees, you are at a significant disadvantage before the fight even begins. You need to understand this clause before you sign. If it is not favorable, negotiate it. If the contractor refuses to negotiate, think carefully about whether this is someone you want to do business with. All right, here's mistake number 5. This is a big one. Failing to include a clear termination clause. What happens if the contract isn't going well? What if the contractor is weeks behind schedule? What if the quality of work is substandard? What if you simply want to end the relationship and hire someone else? Without a termination clause, you may be trapped. You could owe the contractor money for work not yet performed. You could face penalties. You could end up in a prolonged legal battle just trying to get out of a bad deal. A strong termination clause answers critical questions. It defines what constitutes a breach. It outlines the notice requirements, and it specifies how many days the contractor has to cure the problem. It explains what happens to materials already purchased, and it addresses how partial payments are handled. Florida courts look closely at these provisions. If the clause is missing or poorly written, it creates ambiguity. Ambiguity in a contract almost always benefits the party who didn't draft it. So if the contractor wrote the agreement, that ambiguity works against you. I tell every client the same thing. Hope for the best, plan for the worst. A termination clause is your emergency exit. Do not sign a construction contract without one. So let's recap what we've covered today. Mistake number 1, not verifying the contractor's license and insurance. Mistake number 2, accepting a vague scope of work. Mistake number 3, agreeing to a bad payment schedule. And mistake number 4, ignoring the dispute resolution clause. And mistake number 5, failing to include a termination clause. Any one of these mistakes can cost you tens of thousands of dollars, but now you know what to look for. You know what to demand, and you know how to protect yourself. Now, if this video saved you from even making one of these mistakes, do me a favor and hit that like button and share it with someone who is about to start a construction project. And subscribe to this channel so you never miss a video that could save you money and headaches. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.